So I'm going to try to do the review going through the sheet that I gave you guys. Does everybody have it with them or on your computer?
I have an extra copy of some of these ones.
Oh, anybody need one?
I'll take it if it's extra. It's on my computer though.
So number one, by the way, these terms, some of them obviously overlap, and I'm going to go through them the best way that I can, but certainly interrupt me with questions. I usually finish this, within like 40 minutes easily, depending on how many questions there are, and then afterwards if you have other questions. So let me just say first a little bit about exam taking as well as my exam. I'm not interested in knowing what you know in a vacuum about, say, reporting to DCF, right? It's only in terms of whatever the question calls for. So if, for example, you represented a mom and she was facing a 72-hour hearing, as you guys did with Logan Marr and some of the other cases, yes, you might then say, you know what, DCF must have got or did get a call from this mandated reporter, and this is the process, it would have been screened in, et cetera, et cetera. But again, only in terms sort of the question. You don't want to sort of lay it out there as if you're just telling me everything that you know. So very important, what is the call of the question? What sort of position are you placed in? Because you may get one fact pattern that says at the end or at the beginning somewhere, as I just said, you represent the mother, what would you advise her? But in another question, or maybe the same question, who knows, you represent the mother, what is your argument to the court as an advocate, right? So a little bit different depending on, again, the role that you're placed in. You might be placed in the role of the juvenile court judge. What will your decision be? And how will you back it up? Or the clerk to the judge, giving the judge advice on how you think the judge should decide the case. So very important, call of the question is usually always, same thing goes for a bar exam. It's always usually at the beginning or at the end or both. Always look for that in terms of the fact pattern and how you're going to answer the fact pattern. I'll come back to other pointers, but that's the number one piece of advice that I can give you. Okay, origins, philosophy, and goals of the juvenile court. And then talking about the changing goals, as in the YO proceedings, termination of parental rights, the brain research, death penalty cases, life without parole. So how would this come up? It might come up as an argument, perhaps, that a defense attorney or even DCF is making in a CMP case. It may come up again as a judge trying to decide a case. Normally, the reason for the juvenile court in the first place was because rehabilitation should be the goal. The focus is on the offender, not the offense. And it's not like the adult system. Children are not adults, but children, they can be rehabilitated. They should be protected, etc. Right, so that's the original goal, the original philosophy. You still see it in the statute, you still see it in case law. But there are places and areas in juvenile law where this goal could be changing, or perhaps has changed. So one example is the youthful offender proceedings. And what was before the youthful offender proceedings, the transfer hearings, where the goal of rehabilitation and protection is sort of put aside, and in place of it, treating this small minority of children like adults, giving them adult punishments. I'll talk more in detail of the YO cases later on, but one example where the original parens patriae goal is sort of put aside, or in the balance of that versus, say, public safety, right? Public safety wins. And the trial and consequently the treatment and the punishment of children may be very similar to the way that we treat adults. And the due process cases sort of go along with that, right? Starting with Galt and the 4 important rights that children that are facing a delinquency trial get, that are the same exact rights that adults have, and that was notice, rights to counsel, self-incrimination, confrontation, right? Another sort of area where we see sort of the juvenile court again going away from its goal is the termination of parental rights cases, where the focus on care and protection was and is supposed to be strengthening, encouraging family life, DCF being the agency that is out there to help children, help families. Well, when the statute was changed back in '94 and allowed the juvenile courts to terminate parental rights, remember that? So we have 119, which is care and protection, but Chapter 210 is adoption, and the juvenile court judges can terminate parental rights if, and that's where you get into the 2 standards, if the best interest of the child or the children warrant the termination versus the current parental fitness being the standard for the care and protection cases. So you'll see this back and forth, and you may have to talk about it again depending on the context and the role that you are placed in answering the question. We'll come back to this a little bit. Actually, number two sort of slides into the same kind of discussion when the question becomes, are juvenile cases criminal or civil? So remember back when the first kind of cases we talked about were the care and protection cases. The standard of proof at the 72-hour hearing is a civil standard, right? Preponderance of the evidence. Even the standard of proof at the end of the care and protection trial itself is still a civil standard, right? Clear and convincing evidence. But you saw one example when we did the child sexual abuse case study of parents engaged in a care and protection trial that is supposed to be civil, but still opening up to criminal penalties. Remember that the Department of Children and Families had to give notice, right, to the district attorney of the 51A, the 51B, the service plans, all regarded to Lee when we looked at Lee's care and protection case and criminal case. So if you have a case that's either sexual abuse or some serious type of physical abuse, you might be counseling on the one hand your clients that, look, this is a case about children, it's care and protection of, it's a civil case. Yes, it concerns your rights as a family, but worst case scenario in the care and protection case, whether you lose custody and maybe termination of parental rights, but it's not a criminal case. However, the district attorney can still get notice and get information, right, from this care and protection case to possibly indict you and hold yourself out to, criminal prosecution and punishment. So that's CMP. Are juvenile cases criminal or civil? Again, same question. What about CRA, what used to be CHINS, children requiring assistance? Well, again, it's still a case regarding a child, but now instead of sort of concentrating on what the parents have done to a child or not done, neglected in the care and protection case, in the CRA cases, we're talking about an act or acts that a child has done. But the acts are not criminal in and of themselves. They haven't violated a law of the Commonwealth. They've either been disobedient at home, disobedient at school, have not followed the lawful and reasonable regulations of the school, been truant, number 3, or ran away, 4, right? None of those acts are criminal acts. So again, you know, on the one hand, these are civil cases. Child requiring assistance in and of itself is about, again, getting children some kind of help. So happy birthday, Jim.
I said we all sing happy
I was supposed to say.
birthday. How about it? Happy birthday to you. Happy birthday to you. Happy birthday, dear Jim. Happy birthday to you. Thank you.
All right, you too.
I have no cupcakes.
About a day older than 25.
So in the CRA case, as I said, when these were started, when CHINs was first started in the Commonwealth, the idea, the goal, very similar to the goal of the juvenile court itself, was to help children as a sort of prophylactic tool. Let's make sure that if we can give them assistance now, then they won't commit crimes later. Okay? So again, you may say initially, well, a CRA is a civil case, right? But again, just like this, similar to the CMP, a CRA also has sort of criminal aspects itself. Even though the child has not violated the law, the standard of proof in a CRA case is beyond a reasonable doubt. So now the standard of proof has become higher than the CMP cases that we just talked about. The CRA children, actually, just like the CMP children and the CMP moms and dads, have notice and right to counsel. You know, again, due process rights that are normally afforded in criminal cases. And with regard to parents getting counsel, do parents get counsel in a CRA case? Amanda's saying no.
No.
Jim is saying no.
Well,
Do the only if? Are you ready?
I was going to say if there was any chance that a child would be taken from the home or
In whose custody?
in the state's custody.
In DCF's custody, and that was the Hillary case. So normally, yes, so normally the initiation of the case, whether it's parent bringing the case or school bringing the case, it's the child that's going to get counsel in the CRA cases. But again, the Hillary case that was decided by the SJC, if the CF is going to be involved and potentially get custody, then we're talking about parental rights, right? Parents losing custody right of their children. And again, most of these arguments also go right back to the beginning when you guys read those U.S. Supreme Court cases, right? Prince and Yoder, etc. So because parents are potentially losing custody, they get counsel in a CRA case as well. And notice now, the two agencies so far that are involved, Care and Protection, it's DCF. CRA, it's DCF. So again, the argument that these are not criminal cases, the agency that is involved, you know, is not prosecutorial, it's not an agency that's involved in trying to punish the child, it's an agency that's involved in offering services to the family and in helping. And then you go down the line, then you get to the delinquency and the youthful offender cases that I get on their face become more criminal than the previous cases. But even if you look at the definition of the purpose clause of the delinquency cases, it's 1953. It says that these proceedings are not deemed to be criminal, and that children should be treated in needs of guidance or welfare or something like that. It's 1953. So you have that, and attorneys frequently and judges will fall back to that mission statement of the cases that deal with where juveniles have committed criminal offenses. Everything else about the delinquency cases and the youthful offender cases mirror adult-like proceedings, remember the rules of criminal procedure apply, the same rules that apply for adult criminal proceedings, both for delinquency and youthful offender proceedings. The agency that's involved with the delinquents will be and only be DYS. Youthful offenders, depending on, and we'll talk about that, the sentencing hearing, could be DYS as well as the Department of Corrections. So in terms of the question of juvenile cases, criminal or civil, they kind of all have aspects of both. Obviously, the most criminal-like proceeding is your youthful offender proceeding. I'm going to come back to this, but that's just on the issue of criminal versus civil. What about the rights of the family to be free from government intrusion? So that might come up, and probably will come up within the context of either a C&P, either you're told in the fact pattern that there's a current C&P, or it looks like there might be. And you might have to talk about the rights of the family. And that, again, that goes back to your early cases, Prince and Pierce and Yoda, etc. And you may have to talk specifically about, first of all, what are the general familial rights to children that you would be talking about. It would be the 14th Amendment, right? The due process. I have the right to raise my family without the state interfering, etc. And you'd be relying, again, on the rationale from the earlier cases. But you also might be given a case where the parent also has a particular religion. So you'd be adding to that the First Amendment as well. So the right of the family not only to bring up their children generally in education and so forth, but to also practice their religion. You might also have a situation similar to the medical neglect, the ICA case that we talked about as well. So different types of abuse or neglect, and again, either general familial rights that you're talking about, or general plus specific religion, medical, etc. The state's duty to protect, so that's the opposite. So you have on the one hand the family rights, which is not absolute, because when the child's welfare is at stake, that's the state as parents patriae being able to intervene. So the reason behind, if you were explaining, say, to a client, if you're representing the mother or the father, the reason behind the social workers being able to come in and take your kids from your house has to do with the parents patriae philosophy of the state and their duty to protect children. So think of 3, 4, and 5 as sort of the triangle, right? There's parents' rights, states' rights, and lastly, children's rights. And what do we mean by children's rights? Does it depend on the nature of the case? Well, if it's a C&P case, and the children are, very young, and you're told that you represent the child or the children, you want to put yourself in the shoes of the child. Well, if the child were mature enough to make a decision, would the child want to remain in this home with these parents, or would the child want to be free from the abuse and neglect, etc.? So depending on your substituted judgment for the child that looks like he or she, because of their maturity, etc., age, can't make the decision, you would impose your substituted judgment for what the child would choose, right? Different from a guardian ad litem, so you might be given a fact pattern where there's, attorney for mom, attorney for dad, attorney for child 1, child 2, a guardian ad litem, which would be different from the attorneys for the children. So the guardian ad litem would be representing to the court what he or she thinks is the best interest of the child. So it's possible that an attorney, a child's attorney, could be advocating for a return home, whereas a GAL is advocating for staying out of the home and being in DCF custody until and unless this, some help, some services going on, would put everybody back to status quo, et cetera. So, in the nature of children's rights, go ahead, you can interrupt.
I have a
Yeah.
question about that. So I understand the distinction between what the guardian does and the child's attorney. I don't want to throw out a sort of a crazy hypothetical, but just to see how that would play out. So let's say you have dad's attorney, dad wants a kid, mom's attorney, mom wants a kid. State.
Are they at odds? Is
Yeah,
it
they're at
domestic
odds.
violence or something?
No, not necessarily domestic violence, but they're at odds. Maybe both parents are really not good parents. So the state's involved, they want the kid, and grandma wants the kid as well, and kid wants to go with grandma. Is there ever a time that as the child's attorney that you're going to ask the court to appoint the guardian, thinking the guardian's going to find, grandma who has a sweet, loving home is in the child's best interest to sort of...
Whose mother and who?
Doesn't matter. Whichever one of the parents, it doesn't matter.
Well, there's a couple of scenarios here that I'm thinking of. You could represent mom, and it's her mom, and maybe you're going to waive the 72-hour hearing that you're going to want to do as a placement hearing. That was the Mantle case.
Yeah, I'm just wondering if the child's attorney is ever going to request the guardian be appointed.
That's possible. You just have to be careful that you're not in requesting the GAL, that you're not revealing an attorney-client confidence. And most of the time, the juvenile court judges are real, for the most part, specialists. And they really get it when there's going to be some kind of conflict in terms of, what the child wants versus best interest. And usually the court will appoint, and you don't have to be placed in a situation like that. That's a good question. In the very case that I had you guys study, that child sexual abuse case, was the judge that appointed me the GAL. So the attorneys didn't have to ask for that. Also, children's rights you might get into, as I said, does it depend on the nature of the case, such as a school case. So, if you balance a school case versus a delinquency case, and you're talking about children's rights, especially due process rights, much less, right, in the school case versus the delinquency case, because the delinquency case, you're talking about loss of liberty, therefore, the rights that the juvenile has are, again, very close to adult sort of due process rights. The notice, the right to counsel, the right to, proceedings before his or her liberty is taken away, whereas, say, the child facing suspension is going to get the very lowest the minimum procedural due process rights, the notice and opportunity to be heard. Hey, Laura, you're suspended, get out. Okay, but can I talk to you about it? Yeah, sure, but you're still suspended. So I'm going to hear what you have to say. But again, you don't have a similar kind of right to be in school versus the child that might be, placed in DYS, for example. Jonathan?
Are we going to have to know the standard, the constitutional standard for that?
Yes.
For the distinction? I remember it's like a two-pronged standard or a three-pronged standard for what processes do for each right that will be deprived.
Give me
Like you said,
specific.
for suspension, you're not going to have as much process that's going to be due as for like an expulsion or something of that nature.
So within the student cases themselves, no, not necessarily. As long, again, as you know that there are situations where a child can be suspended and ultimately expelled, number one, for something he's done in school,
Right.
being a violation of, school policy, bringing a gun into school, that would be obviously a knife, or having a fist fight in school, versus another situation being charged with, remember that was the difference between 37H and 37H and a half. Remember that was way at the beginning when we talked about those school statutes being suspended and maybe ultimately expelled for an offense that you've committed, that not in school, but that your continued presence in the school causes a substantial detriment. Do you remember that, to the rest of the, so say, Jonathan is charged with, second-degree murder, but allegedly the person he killed, it wasn't on school grounds, it didn't happen, it happened on the weekend, whatever, but the principal, gets wind of it, that you're facing these proceedings, and decides to suspend or expel you. You still have, know that you would have procedural due process rights within the school system itself. And again, it's fine if you're just general as to what we just said, that you have, the notice opportunity to be heard. You absolutely don't, you have the right to bring counsel to these hearings, but unlike the juvenile in juvenile court, you don't have the right to have counsel appointed for you. Okay, so no sort of those general distinctions between the student in school versus the delinquency cases, versus the CMP cases, the YO cases, the murder cases, etc. So, children's rights, again, may mean different things depending on the nature of the case. Now, let's talk a little bit about the DCF, the reporting and all of that. So, as I said before, you're not going to have to just spout this off. It would only be, again, in the context of you answering a particular question. So, reporting child abuse and neglect. It might come up if you're representing a parent. And maybe it's not even, nothing has happened, but a parent has actually just called you and said, I'm getting I got a call from DCF that they're going to be, they want to come and talk to me. Kid hasn't been pulled, maybe, some neighbor or school or whatever, there's been some report. So you might be placed again in the position of giving your client advice. So in that respect, you'd be giving, some simple, straightforward advice as to what all of these mean. 51A is the report itself, right? And the distinction between a mandated reporter and a non-mandated reporter, but they're both under 51A. And the standard is, reasonable cause. Now you might want to have to explain what that is in lay terms, or again, if you would, in another context, if you were reviewing it perhaps as a DCF official, you might talk about reasonable cause differently. But the standard is very low level, threshold standard is there reasonable cause to believe that that a child is being neglected or abused. If that's the case, that initial 51A report is going to be supported. And that's, again, you talking about the 51B investigator. So the reporting is 51A. The investigation and support, if it's going to be supported, is 51B, and that's the duties of the department. So once the 51A report gets screened in, then you're not dealing with 51A anymore, you're dealing with 51B, right? The duties of the department. Duties to investigate. If it's supported, then you're talking about the agency then doing a full assessment of the family, coming up later on, 45 days down the line with a service plan. And remember this, can you have 51As being supported, service plans being prepared with no CMP getting filed? Do you understand my question? Can you? Yes. So it doesn't mean that, so if you have just the fact pattern and the family's being investigated, it doesn't mean that a CMP would be filed, but you might still have to, again, advise the client that this could happen, and it could happen at, at any time if, and then you have to refer to 11924, right? If the department's, the department's goal is, or the department has looked at your case in the sense that they need to look for substitute care because you right now are unable or unwilling to give that care for various reasons, they might then file a care and protection case. Going back the other way, what about the 51A report and it's screened in as an emergency? And then, of course, you're talking about DCF coming out to the home right away within 24 hours and possibly removing the children. And obviously, in that case, they're going to then go to court the next business day and they're going to be filing the care and protection case under 11924. And remember that if that's the case, then you don't even have the assessment yet, right? Because that takes longer than, immediately. The service plan even takes longer than that, right? A total of something like 55 days, right? So you want to remember that while everything's going on, you have agency and whatever the agency is doing, as well as the court stuff. So getting back to the court stuff, so that first day when the worker comes in with his or her affidavit and the petition is called the emergency hearing. And the hearing itself might only last a minute or two. The judge has the same standard as the 51B investigator, and that's reasonable cause to believe that the children are in danger of neglect or abuse. I'm going to do a number of things now on this day as the judge. I'm going to order emergency temporary custody to DCF. I'm going to appoint the court-appointed investigator, which the investigator becomes a qualified expert. That's 21A, I think. And the investigator, investigates, talks to everybody involved, collaterals, looks at reports, and ends up writing a report and recommendation to the court that usually gets done and prepared and filed within 30 days. So it may coincide with perhaps the assessment that DCF is doing as well. So that gets filed, and usually it's around that time when that gets filed that the parties are all coming in again for some kind of sort of status on the case. So the court gets that, and the DCF worker that's been assigned to the case also submits a report to the court, and that DCF worker also becomes a qualified expert. And both of those reports and plans have hearsay in them. So you might be also talking about hearsay and how even though the juvenile court, goes by the rules of evidence and this goes back to the juvenile court being different from adult court, and that in the name of best interests of the children, for example, we have different sort of exceptions to an ordinary sort of adult proceeding. Going back to that first emergency day as well, the investigator and the attorneys get appointed. So attorney for mother, attorney for father, attorney for child 1, child 2, child 3, maybe GAL that day, maybe GAL becomes an issue later on. And then, of course, because the department got custody on that day, the parties have a right, the parents have a right to a hearing 72 hours later. And then you have to remember that the proof of the 72-hour hearing is now higher. It's preponderance of the evidence is the Robert case. Again, you might have to explain that in the context of giving advice to lay people, to your client, or you might be sort of using it in the context of an argument. Again, it depends what role you're placed in. That's the 72-hour hearing. And remember that if you're going to go forward in that hearing, or even if you're going to waive the hearing, that sets the stage Remember the Robert case talks about that, that sets the stage for what's going to transpire in the course of this care and protection case. Because now you have DCF, the agency that's trusted with custody of these children, right, parents patriae, having, quote, custody, and remember custody was also in the definitional part of the statute, has the right to, quote, control the place of abode, one of the hotly contested issues, visitation as well, and list of contracts, sign things that normally parents do. And so pretty much act as a parent. So say it's been, I don't know, a week later or something, or 2 weeks later, and the father calls you, say you're said the father, I keep saying the mother, father says, I haven't seen my kid. So if that's in the facts, you need to talk about that that person now has a right to have visits with his or her child, right? Unless there's a court hearing. So even though DCF has custody, they still have to follow, right, their rules and regulations. And so if they've abused their discretion in following rules and regulations, you can go back to court on abuse of discretion motion and hearing and tell the court my client is not getting visitation. Court would have to decide that visitation would actually harm the child. DCF, again, can't, make that decision interagency to just stop visitation. In terms of the agency, again, following rules and regulations, placement, right? So you have an issue, say, I recommended, that the children's aunt who lives in the neighboring town, it's only like 3 miles away, they could, who has transportation, could take them to, they could still be in the same school system, et cetera. Yet, I heard that they've been placed in this foster home, 15 miles away. Again, that could be an abuse of discretion situation with regard to placement. So be alert for things like that. And those are the two keys. It's the family placement and visitation, where you usually get abuse of discretion issues. And what were the 2 cases that you would cite if you had to? And you don't really even have to know the facts of those cases. Do you remember them? It's the Jeremy and Isaac cases. So that's what those stand for, that normally, normally the juvenile court is not going to make orders like that, but again, if you can show to the juvenile court judge that DCF has abused his or her discretion, then the court is not going beyond its authority to make those orders. Current parental fitness. So, and now we're talking about, I mentioned the emergency hearing, the 72-hour hearing, now we're talking about the final hearing, right? So if you're told that DCF, took custody or got custody of the 72-hour hearing, or there was a temporary hearing and DCF got custody, and now the case is, a year and a half old, and it's getting ready for trial, the issue would be fitness. The ability, the capacity, the readiness, of the child's parent to care for this child now at this time, right? So it's current as of the time of trial. So if it's a care and protection trial, that's the issue. Is the parent or the parents currently fit towards child 1, child 2, child 3? Again, because you could be fit, right, towards one child, unfit towards another.
I have a quick question. When we're discussing the best interest of the child, we need to lay out like a whole listing of the factors that the court will look at? Or we can just say the court looks at several factors?
No, I think you recognize within the fact pattern some of the factors, okay? And, you mentioned best interest, that's the next term. That's only going to come up if either you're told or you can tell from the facts that it might be an issue the DCF's goal is not to reunite, right? But to dispense with parental consent to adoption. And if that's the case, the court is also going to be looking at not only current parental fitness, but the best interest of the child, right? And that's when, Mike, as you said, if you notice that, for example, that 12 months have elapsed and parents haven't, complied with all the services. I mean, it might go to fitness as well, because remember, and the SJC says this, that these tests are really hard to separate. But think of it this way, the court relies more on sort of looking at the child in deciding whether to terminate parental rights, whereas the court is looking and stresses fitness, 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 when it's just custody that the parent might lose. And for the most part, it's not sort of like a surprise. It doesn't happen that you have a care and protection trial where the service plans have constantly been saying, well, goal is reunification as long as parent complies with A, B, C, D, E, F, right? Well, you're not going to get at trial all of a sudden the judge looking whether to terminate parental rights. Usually it's the department changing its goal in service plans and also indicating to the court that this is a parental termination as well. And that comes in, again, within sort of the, obviously the evidence, you guys did the Sissy Harrison case, for example, right? It started as a care and protection case. That's how it was filed, as a care and protection in 1924. But DCF within the care and protection case changed its goal. Goal is always at the very beginning of the care and protection case, unless it's abandonment on one of those, exceptions. The goal of the department is always reunification, strengthen, encourage families, etc. But when you're told, when there's notice of one form or another that DCF is changing its goal, the trial is still the same, it's still clear and convincing evidence, parental fitness, etc. It's the dispositional piece, right, that's going to determine whether parent even wins and gets custody back, or DCF gets custody, or parental rights get terminated. Those dispositions are in 1926. Remember, so it was least sort of scenario was you can even have the children adjudicated in need of care and protection, but get them returned home as well. So all the way up to terminate parental rights. So unless it's a termination of parental rights that the court does after a care and protection case, the case is really not over. Yes, the trial was over, okay, but because parents have not lost parental rights, DCF just has custody of the children for now, right? And under 1926, we're talking about reviews. They can go back to court. Parent can, oh, you know what, 6 months later, I'm free and clear of, whatever my problem was before. I'm going to petition the court for a review and redetermination under 1926. Even if no party does that under 1926, the court itself under 29B holds the annual reviews as well. And because the department, again, being the agency for children, as long as the department has custody of children, the department's going to hold its own reviews as well, agency reviews, foster care reviews. So the case isn't over until or unless parental rights are terminated. And even then, obviously, you have the adoption of blindness case. The case went up to appeal. So there's still the right of appeal as well. If you look at recognizing abuse and neglect, again, you might have a situation where you're presented with a fact pattern, and it just details you might be able to recognize that, this particular child has been, say, emotionally abused by this parent. or physical abuse, or they're, withholding medical because of their beliefs or whatever, or there's domestic violence in the home, etc. So remember that there are, different sort of ways that abuse and neglect could be defined within parent protection law. So again, you might be doing it again in the context of giving somebody advice or making an argument. Maybe you're on, and I haven't even mentioned that, you might be on DCF side, on one of the questions as well. So you want to be able to articulate, what type of abuse or neglect the department is involved in, what sort of, service plans might the department be interested in, and so forth. So I already mentioned termination of parental rights. Rights of parents and children in CMP cases, again, statutory and constitutional. All that means is constitutional is your cases that you read at the beginning, your substantive due process rights of the family. The family, again, having the right not to have the state interfere with the upbringing of their children. Statutory rights, CMP cases is the notice, the right to counsel, those sorts of rights. So you might be having to explain that maybe to your client. You have these rights according to Massachusetts law, blah, blah, blah. Let's see, distinguishing CRA from CMP and from delinquency, I kind of already talked about that. So CRA, again, is not a crime, but it's a case involving children and acts that they've engaged in that they may need, help and assistance. And I just thought of something else. So the overlap of these cases might be important. So you might have just one kid in a fact pattern, and the kid is running away or not going to school, and the kid is also perhaps being abused or neglected. And maybe at school he's assaulted somebody else. So they're sort of all interrelated. And you may have actual court actions, a CRA, a CMP, and a delinquency. Or you might have just one, but also have to recognize that, maybe there should be a mandated reporter somewhere, even though it's a CRA case, maybe it's really a CMP case. So you might talk about, well, if the fact pattern mentions the probation officer sort of a lot, oh wow, well, the probation officer is a mandated reporter, maybe this case is really an abuse and neglect case, and this kid needs help in terms of being neglected or abused by his parents. Or you may have an issue with a kid that's also committing criminal acts as a result, really does need help in some way. The students' rights, we kind of already went over there. Again, you don't have an absolute right to education, but you do have the minimum procedural due process rights to be in school, but the school also has the obligation to make sure that all the other students are safe in school. So regardless of whether, again, you committed a crime in school or out of school, the school may end up, having to suspend or expel you, but you would have, rights to at least say your say before that happens. Your delinquency cases, your procedures, okay. Probably the most important standard that we kind of dealt with, that you see a lot in the delinquency cases when kids end up confessing, right, is the interested adult standard that we talked about, right? So if you have an issue where a child has been questioned by the police, and if you notice that a parent wasn't there, you'd be talking about it. And then if the age is told to you, you might be making a distinction between the child that's over 14 or under 14. So if the child is under 14 and the parent wasn't there, you'd be arguing that a parent should have been there. A parent who would be interested, right, in the child's welfare and understand what's going on and being able to confer with the child. And that even with the child over 14, yes, it's preferred that a parent is there, but with the child over 14, if the parent isn't there, the court also looks at, right, was there this meaningful opportunity to consult? And when the parent isn't there as well, it's up to the Commonwealth. The Commonwealth has to actually show that the child had this, what was called something like high degree of intelligence, et cetera, et cetera. So that could become an issue in a potential delinquency case when you have these confessions.
You said if they're above 14, there doesn't need to be, there's not a requirement for an interested adult in the confession, but
It actually is still preferred.
Right.
So the officers should at the very least say, you know what, you can talk to, we can have your mom come in here if you want.
Right.
So suppose you have the situation where the child says to you, no, that's okay, and the child confesses. And then, I don't know, in your fact pattern, maybe you have that the child has a, I don't know, IQ that's less than normal, for example. Well, then you've really got an issue as to whether that child had actually made a valid, intelligent waiver of his or her rights. Or on the converse, you have a situation where, because we can go all the way up to 18, right? Because remember that the age is up to 18 now for your delinquency and your YO cases, because that was changed by the legislature in September. So say you had a 17-year-old honor student, gets himself in trouble, right? And ends up confessing without parent there, but he files a motion to suppress. Commonwealth's argument is going to be the reverse of what I just said, right? I offered him, he said he understood, he's been in trouble before, not only has he been in trouble before, but he studies, criminal justice in school or something like that, right? High degree of sophistication, et cetera, made a valid confession because he's, almost 18, because he's smart, et cetera, right?
But it's their burden of proving.
Yes, yeah, if the parent isn't there and they're over 14. Yeah.
Does Massachusetts require the Benoit warnings?
The what?
The Benoit warnings?
The what?
Benoit?
I don't know what you mean. Miranda?
Well, it's a form of Miranda in New England. It actually came out.
Give us an example so we can talk
Wait,
about it.
Benoit is a requirement in a different state, New Hampshire.
Yeah.
Under the Miranda warnings, between the ages of 14 and 18, it has a similar statutory concept in regards to not having a parent there. And if you read the Benoit warnings, they're similar to Miranda. They have the same first 5 Miranda warnings. You have the right to remain silent. But under the right to remain silent, it gets into specifically what that means. It says what this means is that you don't have to talk if you don't want to. And it's real plain language, but they're long paragraphs.
Nice.
And they actually
Very nice.
explain.
Yeah.
It says you have a right to talk to an attorney. And then it gets into more specifically. This means
what that means,
what
rather
that
than
means, you
just
can
this
call an
legal
attorney.
mumbo jumbo that a
Right.
kid might not understand.
But that,
Yeah.
that's not required.
No. What's another waiver? Waiver of right to jury trial, right? Not something that would be the nature of some kind of motion, because usually the child is in court with, number one, with his or her parent, has the right to counsel, so again, he or she is in court with his or her counsel as well. So relative to your waiver of jury trial, your tender of plea, right? The court, yes, has to be satisfied that the plea that you've just made or the waiver of jury trial is knowing, is intelligent, that you've conferred with counsel. But the safeguards are already there for something like that. Relative to the confessions, again, the number one sort of motion to suppress that defense attorneys file for juveniles is based on interested adults. So you would think that police officers want to make sure that kids have somebody with them. And remember that somebody could be even a grandfather, you know, can't be like a big sister or something like that. So it really has to be some sort of guardian that not only is concerned for the child's welfare, but also understands, you know, what's going on and can communicate that to the child as well. Probably the most confusing, and I'll sort of end with this and then questions, is what happens in the youthful offender cases. So we know that in the delinquency cases, it's a child right 7 up till 18 who has, violated or allegedly violated criminal law of the Commonwealth or a town ordinance. Okay. So with the youthful offenders, the distinction was 14 to 17. Now it's 14 to 18 because the age was raised, right? And the most confusing part of these cases, especially when you're reading some of these older cases, is how are these kids treated as adults, blah, 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 blah. So when the youthful offender statute was passed in Massachusetts, it did a number of things. It stopped or got rid of the transfer hearings, which meant that and means that there are no proceedings in Superior Court against juveniles except murder proceedings, just murder. And murder, again, from age 14 and up. So if you have a real horrendous fact pattern and the kid is 13, he's not going to go to Superior Court. He's not even going to be, he won't even be indicted as a youthful offender because he's 13. So youthful offender age is 14. It will be a delinquency complaint only, with worst case scenario, commitment to DYS. So youthful offender, again, 14 and up, 14 to 18. Again, except for murder, youthful offender, trial is in juvenile court. And probably the one that you'll be, faced with talking about in terms of is it going to be delinquency, is it going to be YO, it's going to be the kid who's allegedly inflicted serious bodily harm to someone else. And the discretion is in the district attorney whether to do this as a delinquency complaint or as a YO complaint, a YO indictment, I'm sorry. So you might have a fact pattern where you haven't been told, right, and you might have to talk about it, or you might be placed in the district attorney's, and answer that way. Or again, you might be, maybe the parents have called you sort of like in the middle of the night, and we know that something's going to happen to our child, but we're not sure what. You might have to give advice. Well, you'd be representing the child, not the parents, but. So remember that the choice is district attorney. It's not the court whether to indict this youthful offender. Number one. And then again, the trial is heard in the juvenile court. And it's just similar, and in that sense, very similar to the delinquency trials. District attorney prosecutes. Once the district attorney, once the trial is over, and the DA has proven all of the elements of that crime beyond a reasonable doubt, the trial phase is over. And then the sentencing hearing, the dispositional phase, is the part of the case that concerns not the offense but the offender. So very similar to the old transfer hearings, now the court holds this sentencing hearing to determine, sort of in the name of public safety, what should now be done with this kid. And that's when both sides can present any and all kinds of evidence relative to what should be done for his or her sentencing. And the court now has 3 choices. Whether to give that child a ordinarily delinquency type of disposition, commitment to DYS, and that's it. So that's just like it could end just like a delinquency case ends, right? Or a combination, DYS for a time, Department of Corrections for a time. And then the very last one is the exact sentence an adult would get, the sentence provided by, and it says in the statute, the sentence provided by law. So that's when we talk about, treated like as an adult. Yes, the trial is in juvenile court, but the punishment could be an adult punishment, depending on the kid, depending on the type of crime, potential for rehabilitation, anything and everything that you want to talk about.
Could you just say those three factors, the three choices one more time?
Yeah, a delinquency, a commitment DYS, delinquency. Commitment DYS plus a Department of Corrections, that's called the combination one. And then the adult one is called the sentence provided by law. And that's sometimes when you get into some of these mandatory ones, right? The sentence provided by law might be, I don't know, whatever it is for manslaughter, 20 years, 15 years, etc. While I'm sort of looking through my notes to see if there's anything else I want to say, does anybody have questions? Questions? Oh, what about the whole life without parole, life with parole stuff, right? Anybody want to talk to that? Questions about that? Laura?
I have questions on something else.
Okay, ask your question, I'll come back to that.
Okay, we referred, and I noticed in my notes the same thing, 2 different timeframes for the service plans. The one was 45 days and one was 55 days.
Yeah, there's the assessment, and I forgot which is first. So you have, 51B gets investigated, right, by DCF, the investigator. Then the investigator supports and writes up her little report, right?
Mm-hmm.
So if it's supported, then the DCF sort of now, because the 51B investigation is sort of so short, the department now does an assessment, which is sort of a longer looking at the family. I'm pretty sure, yeah, the assessment is first.
Yeah.
And that's 45 days. And then the service plan is 10 days after the assessment, 55 days. So that's the distinction between the 45 and the 55 days.
Okay, thanks.
I think I did talk about everything I wanted to mention, besides the life punishments.
Service. 10 days after the assessment.
So if you have a fact pattern where it's a homicide, and now because it's Massachusetts, you want to be able to talk about the possibilities are probably going to be, the manslaughter or second-degree murder, some form of manslaughter, because the SJC, and again, you didn't have those cases in your package. It's Diachenko and Brown that held in December, Massachusetts, any form of life without parole violates the Mass Constitution. So the district attorney is not going to indict for first-degree murder because we can't give kids life. Instead, the indictment would be either second-degree murder, which would be adult court, or manslaughter, which would be your youthful offender case. So again, if you have a homicide and nothing's been filed yet, and you haven't been told in the fact pattern, you would talk about those 2 choices. And again, the choices are the district attorney's choice, whether and in what court to indict.
Question.
Yeah,
Can you repeat that again about the breach?
I don't know. I broke my water bottle.
Oh, I'm sorry.
Floor, I didn't
No,
get to
no,
drink
no.
anything. I'm getting pretty dry right now.
So the DA has
The DA has the choice. So if the kid has killed somebody,
If all the elements of second-degree murder
Mhm.
fit, then the juvenile court doesn't have jurisdiction over the
No, but
bodies.
the choice, okay, so
Choice is
suppose
made
you
by
have a
the DA.
case where, you and Michael get into a fist fight and you actually end up killing him, right?
Right.
And you're 14. Right? The DA might indict you, and you're in juvenile court, might indict you for manslaughter, or DA might decide to take out a second-degree murder indictment, and that means you're in adult court. Change the facts. Suppose if you're 13, even if you hacked him to death in a grisly murder, it's not going to be a YO case. It's not going to be in Superior Court for murder because you're under 14.
So the DA involvement is like what's probably going on in Connecticut with the Marin Sanchez case?
Yes.
So
Yeah, I don't know what if they do transfer hearings or, I'm not sure. Does anybody know? Would you know, Sandy?
They do transfer hearings, but it's really similar to here, and so that
Okay.
you have to, the same process, and then you have just about the same amount of time.
How old is that kid? That's high school age, right?
16.
Yeah, because that, in Connecticut, everything sticks from that point, so.
Yeah, yeah.
From 16
Mhm.
on moving forward,
Mhm.
but it's similar to here.
Yeah.
So I'm sorry. No, so the DA would be deciding what court and what to charge then? Is-
Yeah.
Yeah, and you normally, when you see a newspaper talk about it, they're always saying treating like an adult or treating like a, but that's so general, you don't know exactly what the procedure is in that state.
But in Connecticut, it's 16 as opposed to.
What's
The
16?
The treating of the, as an adult.
You mean it's 16 and up?
16 and up, yes.
Oh, okay, as opposed to like our youthful offender, which is
Yes.
14 to 18, okay.
Yes.
Interesting. Any other questions? Because I'm gonna give you guys, I need to pass out the evaluations too, so you have some extra time. When is the final?
21st.
21st, what time? 6 o'clock for everybody, online and day students.
What room is it in, the 216?
I don't know what room we're in. I imagine it's gonna be posted by that time. Can I have somebody responsible, a responsible person take the envelope out?
Yeah, where's it going to go?
Front office.